It's June 2018 in the small township of Sempoa in Ghana's eastern region. A young girl named Mary walks through the streets carrying a basket of kenkey, trying to make a few cedis to help her family. She's a student at Blessing Primary School, believed to be just 14 years old and too young to understand how one encounter would lead to such a legal tussle. That fateful day, she crosses paths with Havo, a 19-year-old Okada rider who plies his trade in the town. He approaches her with smooth words and false promises and lures her into his room where he has sexual intercourse with her. Just like that. Mary leaves carrying a secret that her body would soon reveal. A month passes and Mary starts feeling unwell. Her body was changing in ways that she could not comprehend. Her family rushed her to Sempoa Health Center, worried that it might be malaria, typhoid, or something they could treat with tablets. But the doctor's examination revealed something that changed everything. Mary was pregnant. The questions came fast and hard. Who did this? At first, she was silent, perhaps afraid, perhaps ashamed, or even simply confused. But eventually, after much convincing, she gave up a name, Havo, the Okada rider. Mary's brother Richard didn't waste time at all. He marched straight to DOFSU, the Domestic Violence and Victim Support Unit at the Betifi, and lodged a formal complaint of defilement. Defilement is one of the most serious offenses in Ghana's criminal code. It attracts a minimum sentence of 7 years, up to 25 years imprisonment. The judge is not at liberty to reduce your liability whatsoever. Havo was arrested and brought before the circuit court in Mpraeso in the eastern region. Havo stood before the judge and the charge was read out clearly. Defilement of Mary, a 14-year-old girl, and Havo pleaded guilty. He admitted to having sexual intercourse with Mary. The judge had no choice under law. The mandatory minimum sentence of 7 years was delivered by the judge, and Havo was taken away to begin serving his time in prison. The story was only starting. Havo launched an appeal against his conviction. The question that was obvious was, why would you appeal when you've already admitted guilt? What possible grounds could there be? The answer lay in a single crucial detail that would unravel the entire case: age, specifically Mary's age. Havo's counsel came forward with an affidavit sworn by Mary's own father, stating that his daughter was not 14 at the time of the incident, she was 16. Defilement is having carnal or unnatural carnal knowledge of a child under 16 years of age. 16 is the line. If Mary was 16, then legally there was no defilement and the charge would be defective. The conviction would be unsafe and everything would fall apart. The prosecution, however, fought back. Counsel for the Republic argued that since there was no documentary evidence to support this claim of 16, it should not be entertained. Where was the NHIS card or a birth certificate or a weighing card or any school records to show that indeed the child was indeed 16? They wanted to see relevant documents. But they brought the charge themselves, and when they filed it, they only wrote that Mary was 14 years old. There was no date of birth or supporting records backing the charge, just an age stated as a fact. The appeal landed before Justice Cynthia Martinson at the High Court in Koko. She had to evaluate the merits and untangle the conflicting claims. But as she examined the record, she discovered something troubling. The prosecution indeed never actually proved Mary's age. They simply stated it, as if saying it made it true. But in law, especially in a case as serious as defilement, where a man can lose 7 to 25 years of his life, you can't just state facts. You must prove them. Justice Martinson took the view that even though Havo pleaded guilty, the court could still entertain his appeal, especially where the facts as admitted would not have led to a conviction in the first place. The record showed that the prosecution failed to prove Mary's date of birth. The trial court had the duty to satisfy itself of the child's age because it was so essential to establishing the charge. The burden of proving all the essential elements of a charge was always resting with the prosecution, and they failed to do so. The prosecution's argument asking for relevant documents was an attempt to shift the burden, and Justice Martinson was not having it. It is not the accused person's responsibility to assist the prosecution. His responsibility was to raise doubt, and by presenting that affidavit, he had done exactly that. The finding on the record that Mary was 14 years was therefore not supported by any evidence, and the failure of the prosecution to establish same was fatal. The appeal was successful, and Havo had suffered a travesty of justice, and his conviction was set aside. The court was not even inclined to order a retrial because Mary's own father had submitted an affidavit to the effect that she was 16. After all the drama, after all the pain, Avos was successful. He was released unconditionally. But this vindication was delivered all the way in October 2024. He may have spent nearly 6 years in prison before courts finally acknowledged that his conviction was built upon a very flawed foundation. The case is a reminder that in criminal law, especially where the stakes are measured in decades of imprisonment, every detail matters, every piece of evidence counts, and every element of the offense must be proven beyond reasonable doubt. Follow Super Law GH Studios for more real stories, real cases, real people.